afternoon. I see the doors closed, so that must mean it's time to start. Welcome. We're excited to see the few tenacious people who stuck it out with us till the end. As you know, today we're going to be talking about how to achieve permanency for children whose parents receive services from the Agency for Persons with Disabilities. Am I too loud? No. Okay. Sounds like it. My name is Laura Lee, and I'm a senior program attorney with the Guardian Ad Litem Program Appellate Team. With me is Janet Anderson. She is a senior best interests attorney with the Guardian Ad Litem Program in the 20th Circuit over in Fort Myers. Before we get started, I want to get a feel for who's in our audience. How many of you are with the Guardian Ad Litem Program in some capacity? A lot of you, okay. How many are GAL attorneys? A lot of you. Do we have any CAMs? Any CAMs, yes. Any volunteers? Yay, volunteer. Do we have anybody here from the department or a CBC? Great, okay. Attorney, case management? Attorney, okay. And do we have any parents attorneys? Yes, okay. We are specifically going to look for your input when we get to our best practices a little later in the presentation. Have I missed anybody? Anybody here from anywhere else? Yes. You work for the Agency with Persons with Disabilities, an expert, yes, okay. Okay, great, glad you're here. One more question. How many of you have had or currently have at least one case, a dependency case, in which the parent is receiving APD services? Okay, more experts, perfect. All right, so we'll go ahead and get started. If I can make the clicker work. Or not. Okay. So the Agency for Persons with Disabilities was formerly known as the Developmental Disabilities Program, and it was under the auspices of the Department of Children and Families. In October of 2004, it became its own separate agency, and currently APD serves over 50,000 Floridians. So basically what the Agency for Persons with Disabilities does is it serves developmentally disabled people who would otherwise require institutionalization unless, the services were provided. So they support people with developmental disabilities in living, learning, and working in their communities to hopefully facilitate as close to possible a normal living and working routine. In order to do that, APD works with the communities and individual private providers. Significant for our purposes today, and I'm forgetting to click, I'm sorry. Significant for our purposes today is that APD operates the Medicaid Home and Community-Based Services Waiver Program. Now we hear Medicaid, we hear federal government. As you can imagine, if the federal government is involved, you're going to see a lot of bureaucracy. But don't panic, hopefully your eyes won't glaze over. We're going to keep it to a minimum and just enough to give us a context of the layers and what we're dealing with. Okay, as we probably know, Medicaid is a cost-sharing arrangement between the federal government and the states, in which the federal government reimburses a portion of the expenditures incurred by states that elect to furnish medical assistance to individuals whose income is insufficient to cover it themselves. Medicaid program is administered by the Secretary of the Department of Health and Human Services. So Medicaid eligibility is basically an income test. People who are institutionalized will generally qualify because what they look at is the net income after the cost of institutionalization. And as we can imagine, institutions are expensive. So because institutions are costly and generally not the most ideal for people, the Medicaid Act includes a waiver provision. Under the waiver provision, the Secretary may grant a home and community-based services waiver that operates to waive certain statutory requirements under the Medicaid Act for states that wish to provide home and community-based services to certain persons who would otherwise need nursing home or institutional care. So what it waives, it kind of changes the statutory definition of what medical assistance is and makes home and community-based services qualify as medical assistance. If, but for the home and community-based services, the recipient would require institutionalization. Now, normally if someone has institutional care, their room and board is automatically included in that cost, but under the waiver, room and board is not a reimbursable expense. However, if the recipient has an unrelated caregiver living with them, that room and board for that person might be reimbursable. Okay, so what kinds of services are we talking about? Under the Code of Federal Regulations, we've got a list here of the available services. So there's case management services, homemaker services, again, that's in the federal code. That, under that nomenclature, has been eliminated in Florida, but the same types of services are provided in the in-home support services. So a recipient might receive home health aid services, personal care services, adult day health, respite care, habilitation services, which are aimed at assisting the individual in acquiring, retaining, and improving their self-help, socialization, and adaptive skills to enable them to live successfully in their community setting. The expanded habilitation services encompass things like your pre-vocational services, educational services that are otherwise unavailable, and supported employment services. There's also a catch-all of other services that would be approved by the agency as cost-effective and necessary to avoid institutionalization. Okay, so in order for a state to participate in this Medicaid waiver program, the state submits a waiver proposal to the Secretary, and it must indicate that there's a reasonable expectation that home care would cost less than institutionalization, and it has to be approved by the Secretary. Of course, federal due process requirements also have to be satisfied, and those are detailed and lengthy, which we don't really need to get into for our purposes. Once a state is approved, they are in the program for an initial 3-year waiver period, and then that's renewable for 5-year periods. Okay, the state has to agree that for each recipient under the services, that they will provide a written, person-centered service plan that's created by the recipient and people chosen by the recipient. It's very individually driven, with a focus on that individual choice. There has to be the necessary information to enable the recipient to make informed choices. It has to reflect the recipient's cultural background. And the key is that we want to facilitate the individual's choice regarding both the services as well as who provides the services. And here in Florida, we started participating in the Medicaid waiver program back in 1981, and it is administered by the Agency for Healthcare Administration. Now, those of you who are still awake are saying, wait a minute, she just told us the Agency for Persons with Disabilities administers this program here in Florida. And yes, I did, you are right. And this is another layer of that bureaucracy. So we've got Health and Human Services under the federal government, then we've got the Agency for Healthcare Administration in Florida, and then we'll talk about how APD fits into that. One of the things that the Agency for Healthcare Administration does is publish the, and this is a mouthful, Developmental Disabilities Individual Budgeting Waiver Services Coverage and Limitations Handbook. And that is a 200-plus page document that includes all of the details about what the services involve, who can provide them, what the qualifications are, so on and so forth. The last version of that handbook was updated in July of 2017. It is incorporated by reference into the Florida statutes and the Florida Administrative Code. And at the end of our slides, we've got a link if you're interested in looking at that. Okay, so between the Agency for Healthcare Administration and APD, there's an interagency agreement that creates an accountability system to ensure that the services on each support plan for each recipient are necessary to avoid institutionalization. So again, it goes back to that federal requirement under the Medicaid Act. The Agency for Persons with Disabilities is responsible for the day-to-day operation of what they call in Florida the I-budget waiver. That was a created process by which the funds that are allocated to purchase services can actually be obtained. So the APD, in order to do that, contracts with individual service providers, so that creates kind of another layer to our bureaucracy, The service providers must be Medicaid providers through the Agency for Healthcare Administration, and their agreement between them is known as the Medicaid Waiver Services Agreement. And my clicker does not want to work. Okay. So how does someone obtain APD services in Florida? The applicant must have a developmental disability as defined in the Florida statutes, Chapter 393, and the Florida Administrative Code. The individual applies directly to APD, including their qualifying diagnosis and the services they're requesting. Now, at the application point, they may not be entirely sure what services they're requesting, so they're not set in stone and they're not stuck with that. That can be reevaluated as long as whatever they look at later is medically necessary. Once the application process is started, the next step is a questionnaire for situational information, or the QSI. That is an extensive 40-page, more than 40-page document with very detailed questions about the applicant's needs, their situation, their circumstances, so on and so forth. That QSI has to be administered by a trained assessor. So what happens is our QSI assessor will meet with the applicant, their family, basically whoever the applicant would like present at that time. And they'll just also discuss further the desired services that they're looking for. And that QSI is re-administered every 3 years. Okay, so under the Florida statutes, developmental disability is defined as a disorder or syndrome that is attributable to an intellectual disability, cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermid syndrome, or Prader-Willi syndrome. It has to manifest before the age of 18, and it must constitute a substantial handicap that can reasonably be expected to continue indefinitely. Now, that doesn't mean that there's no possibility of improvement or that the applicant can't learn new skills, things of that nature. It just means that that disability is likely to continue with them. Okay, so what kinds of services and treatment are we talking about? Again, has to be medically necessary to prevent institutionalization to qualify with the Medicaid Act requirement. And of course, services can't be provided if we don't have the resources to provide them. So Chapter 409 of the Florida statutes specifically authorizes the Agency for Healthcare Administration to eliminate or limit coverage for certain services. So we're going to go through what the statute in Florida lists as possible services, but just because there's a service listed in the statute doesn't mean that there's actually resources for it, as we'll see shortly. The services cannot overlap, and certain services may have hour limits applied to them. Janet will touch on that a little bit, but it might be, say, 8 hours a day or 20 hours a week or, whatever. And of course, the services have to be responsive to the individual's needs and encourage their recipient's control over the resources. All right, so under the statute, there's a list of possibly available services. As you'll notice, I've got asterisks by some of these. They largely mirror the list of services that are in the Code of Federal Regulations, but I do want to touch on, when we saw family care, Janet and I thought, this could be interesting for our purposes in the dependency system, but basically we found out that was just a financial benefit in situations where the recipient moves in with a family member and that arrangement causes a financial hardship. They can apply for this financial benefit, so it really doesn't impact us in dependency that much. Parent training sounds very promising. However, that's one of those things that the Agency for Healthcare Administration has eliminated at this point in time as not having resources for that. So, continued list of services under the Florida statute. Again, largely mirrors under the Code of Federal Regulations, those habilitative and rehabilitative services. We see a lot. And then this is just a page out of that handbook I mentioned. There we go, just to show you that under the iBudget system in Florida, they group the services into service families. So you've got your life skills and supplies and equipment, personal supports, things like that. Goodness gracious. Okay, so what is this I-budget? How does it get created? The I-budget is the actual dollar amount that is allocated for resources for each individual recipient. It is determined by APD, and it's based on that QSI assessment we mentioned before, as it gets plugged into an allocation algorithm amount, which is very detailed, and we don't need to know about that. There's also the possibility of getting approved significant additional needs funding through a separate additional application process. Once APD figures out that total dollar amount, it gets included in the notice of agency action that is sent to the recipient when their application is approved. The budgeted amount can change, but only if there's a dramatic change in circumstances that would result in an inability to meet the recipient's health and safety needs. So it's a high bar to get that amount changed. And just as a side note, most applicants who are approved are waitlisted, and it's a pretty extensive wait list and pretty lengthy. And the Florida Administrative Code lists out the prioritization for the wait list. So you're aware of that. But for our purposes, let's assume our applicant has been approved. How do we get the ball rolling? The key person in all of this will be the Waiver Support Coordinator. They basically will work with the recipient to determine which services they would like to choose for Medicaid reimbursement out of that I-budget amount after exhausting natural supports. Natural supports are resources that are uniquely available to the recipient. So it can be a family member. Maybe Aunt Sally is retired and has a few hours every morning to come over and help with medication management, getting breakfast made, planning meals, things like that. It can be church or community resources that are available. It can be other Medicaid services that are available. There's a strong emphasis in the I-budget process for the Waiver Support Coordinator to really be creative in looking at each recipient's situation and what resources they have available, because they won't want to even start looking at what's going to be reimbursed by Medicaid until they've exhausted those resources. So the Waiver Support Coordinator is actually contracted with APD, and they are paid out of that I-budget amount, so that's part of that budgeted amount. They are chosen by the recipient. We said individual choice is key, and they're subject to change at any time based on the recipient's wishes. The support coordinator cannot be a service provider because they have to be able to be an independent advocate for the recipient. So basically what the support coordinator will do is meet with the recipient and whoever the recipient would like present to discuss what services they're looking at. They will help the recipient identify their capacities or strengths, their needs, like I said, their resources. It will help them in actually accessing the services. The support coordinator will serve as an advocate for the recipient, and the support coordinator will also monitor how things are going once the ball gets rolling. So basically, back to those federal regulations, they're there to support that person-centered planning process. Of course, since it's an annual support plan, it gets updated every year. And basically, it's a detailed breakdown of specifically, this is the amount budgeted, we're going to spend X amount on this service, and it will be provided by this provider. And it just breaks everything down. Okay, so once the annual support plan is created, the Waiver Support Coordinator will generally meet with the recipient on a monthly basis to assess the services, the progress, how things are going, monitor for any problems. I should mention that there are different levels of support coordinator services available. What I'm giving you is just a general how the time frame and requirements work. There are some recipients who would qualify for 24/7 support coordinator support, so it just depends on the needs, going back to that QSI. Then generally, the support coordinator will meet quarterly with the recipient and all the service providers, again, to see how things are going, monitor for any problems. If the support coordinator sees things that maybe aren't working as well as he or she thinks they could, or thinks maybe a different service or a different provider would be better for the recipient, they can make those suggestions, but as long as the recipient is a competent adult, he or she is in the driver's seat. Okay, and I apologize, oops, I skipped right by it. That last slide was out of order, and I already covered the natural supports like we talked about. So the pole star of the whole Medicaid waiver program is that waiver services are 100% directed to the waiver recipient. And that's going to be really key as Janet starts looking at how all of this applies to our dependency context. I'll turn it over to her.
Good afternoon. First, I want to preface my comments with the statement that being an APD recipient is not the basis for your child entering the dependency system. Children enter the dependency system due to abuse, neglect, and abandonment, regardless of the parent's status in APD or not. And so we're looking for realistic expectations of the partnership between the APD program and dependency. And can a parent's, or should a parent's, APD support worker be part of a reunification plan? And we're also asking, what role does the support worker play in the parent's dependency case, and what are the challenges and pitfalls? As Laura pointed out, the recipient has freedom of choice. The I-budget waiver is designed around that choice. Recipients can choose from among enrolled qualified providers, and the recipients can change providers at any time. And they can also fire their individual APD worker at any time. An enrolled qualified provider is essentially a subcontractor who hires, trains, and places the APD workers. Over there, okay. So we're looking to ensure that anytime there is a change, we don't jeopardize the recipients, the APD recipients' health and safety, that the services provided continue to meet medical necessity, and very importantly, does not exceed the I-budget total. When changing providers, it must be ensured that there are sufficient funds to cover any unbilled amounts from the original provider that may come through after the change is made. And Laura pointed out that we also want to look to the natural supports for the APD recipient, the unpaid supports that may be supplied voluntarily in lieu of waiver services, so that will stretch the waiver dollars if we have others who can provide those services, family members, church members, community organizations. And all of this also rests on the support worker. We look for the changeover due to their age, their health, their schedule, any other responsibilities they may have. So what we have in many cases is a lot of turnover among APD workers. The services provided to the parent, and I'm switching from APD recipient to parent now because we're in a dependency case. They must be in direct relationship to achieving the recipient's goals as specified in their support plan for items such as medication management, transportation and scheduling of appointments, and daily living activities such as shopping, cooking, paying bills, and budgeting. The plan is goal-driven for the parent. However, to be a better parent is unlikely to be part of the goal. So the services provided by the APD support worker are limited as to the amount, the scope, the frequency, the duration, and the intensity pursuant to the support plan and the approved cost. All of this sounds very highfalutin. Bottom line, the APD worker works within constraints of how many hours and how many dollars can be paid for them to provide assistance to the recipient, and in this case, to the parent, and also governs the nature of the assistance the APD worker gives to the parent. In a dependency case, specifically, we should be gathering important information for a realistic assessment. Now remember, our child came into care due to abuse, neglect, or abandonment, not because the parent is an APD recipient. So we should be gathering information aimed towards reunification with this parent and get as much as we can to support the parent. One way is to obtain the annual support plan to see what it is APD is offering to this parent. And in order to do so, we must obtain a signed release from the recipient. APD will not give us any records without that signed release. So that once we have that, we can request APD documents, and as I said, especially the annual support plan. And this presentation is sort of based in this I didn't do, so now I know I should have, okay? I have a couple of cases where the parent is an APD recipient, and all of this information about APD did not come out until very late in the cases. So I'd like to take it from inception at shelter, or the first time you find out that your parent is an APD recipient. It would behoove the department, it would behoove the guardian, and it would behoove the parent's attorney to obtain the release for the annual support plan and get the name and contact information for the waiver support coordinator. This is a key person in working towards reunification. In your packet, we do have a copy in our packet that you don't yet have, or you've downloaded. We do have a copy of the APD release form to be used to get those records. So like I said, this presentation is based on a don't do as I do, but do as I say approach. Now that I have the information.
If I could just interrupt for a second. We found that the APD regional operations director, specifically in the 20th Circuit, was very helpful. If you have questions at the end of our slides, we've got a list of the contact information for all the different regions. So if you need the release form or whatever, they're very helpful and willing to work with you.
Yes, ma'am.
I just want to know, we just use a standard HIPAA release form and we always are able to get records. So
And where are you?
we're Disability Rights Florida, we work all over the state.
Oh, okay. Well, again, yes, ma'am, from APD.
So I'm that person for the central region, so. And you're talking about Jasmine, Reese, fantastic, so.
Okay.
With the 20th, that's the.
Yeah, actually, we had a,
Taylor is who.
The deputy.
Okay, that's who we were working with. Okay.
I worked with him for.
okay. So when we're looking at the support worker, we're looking at the payable activities that support worker undertakes. So again, the annual support plan has the dollar budget, which then gets converted into the hours of work for the support worker and the types of things that the support worker will do. The hours of work do not have to be consecutive. They just cannot exceed the budgeted hours. So the hours of work may vary daily, depending on what the recipient's needs are. I know that I have one parent has the support worker comes in at 7 o'clock in the morning, helps with getting breakfast and med management and various other things, and may then accompany the parent to doctor visits, and by 11 o'clock, she's completed the morning's activities, she leaves the home. She comes back at 5 and handles dinner and evening med management, whatever else, and is out the door at 9. She has an 8-hour day, but it's not consecutive hours that she is working. She would only be paid for the contracted number of hours and only for the services in the annual support plan, and only for the services provided to the APD, in this recipient, in this case, the parent. And this is where we get in a little bit of a gray area. Anything other than the number of hours contracted and the types of services in support of the plan offered could be considered Medicaid fraud if payment were received. The APD worker and the parent, however, could live together. That doesn't mean necessarily that the parent gets 24/7 services. Those are very, very difficult to obtain because there needs to be a medical necessity for 24/7 care. But the APD worker may move in with the recipient, or the recipient can move in with the APD worker. But we're still talking about providing the agreed-upon services within the agreed-upon time frame, so the APD worker sort of fluctuates back and forth between roommate, I have no responsibility for you, and APD worker during my 8-hour day, whatever those 8 hours are. The support worker may tend to their own personal business, leave the home during their unpaid hours. This arrangement may be very successful, but in my cases has been abysmal. The falling out between the APD worker and the parent has necessitated that the parents move frequently. The fact that the APD worker is an at-will worker and can be fired by the parent at any time, when the living arrangement is contingent on the APD relationship, the parent has to move frequently. In a dependency case, a stable home is a requirement for the parent to move through the visitation process from supervised to unsupervised to overnights. And we have parents who are stalled and not approaching reunification, in part due to their unstable living arrangements. However, the program, the APD program, emphasizes the individual freedom of choice of the recipient. And so that provision that they can fire the worker at any time is a very important one. Flip side is support worker can quit at any time. And the contractor who supplies the APD worker must find a replacement. And of course, the support worker has a life, and they may become unavailable due to their own personal issues. I don't know how it is in any other circuit, and I don't know how it is with any other community partner. But in our circuit, supervised visitation is a very difficult thing to provide. We have limited resources for supervised visits. We have court orders that set a minimum number of visits and a minimum time frame. And we must look beyond the service provider, the case management operation, for supervisors of visits in order to increase the amount of availability for any given parent. And based on my personal experience, again, I'm jaded, I'm sorry, but our case management organization is very easily convinced that the APD worker should be the supervisor of visits. They're with the parent all the time. Very often, they are providing the transportation for the parent. They may live with the parent. How much better can it get? Yet, they are employed at will by the parent, can be fired at any time by the parent. So there is some question as to their objectivity in observing visits. And so we ask the question, does the APD worker accompany the parent when the parent is doing other case plan tasks? We have a psychological evaluation scheduled for the parent. Yes, the APD worker, maybe, they help them maintain their appointments, they provide transportation. So naturally, the APD worker would be there when the psychological evaluation takes place. But does the APD worker fill in the blanks for the parent when questions are asked? How much of an evaluation, how does that influence the evaluation? Would the APD worker accompany the parent when the child is visiting a doctor? Who gives the doctor the child's background information? So we have some concerns here, since we are looking at parenting ability with an eye towards reunification. The parent, we need to see some independent action on the part of the parent as far as providing medical history for a child, learning about any treatments or medications the child might require. We cannot rely on only the APD worker to fill in all the blanks. There are obviously some conflicts of interest for the APD support worker in the dependency arena. The support worker's efforts are directed to the APD recipient, to the parent, not to the child. And again, they can be fired at any time, and they can quit at any time. So for these reasons, I would suggest that the APD worker not be offered as a visit supervisor for the parent. They cannot be required to maintain any documentation as a visit supervisor might be required if they worked for the case management organization. They are not objective. They have a fear of being fired if they report something negative. And they also begin a relationship with the child, which, as at least I have seen, the revolving door of APD workers through the home of the parent would create a very uncomfortable and unstable situation for the child. If the child starts getting attached to the APD worker and the APD worker is fired and we have a new one and we go on and on like that, it's not in the best interest of the child to have that happening. Additionally, we would recommend that the APD worker not function as the safety manager for the parent. And then we also have to consider, how would the APD worker be as a witness at a judicial review, at a motion hearing, and finally, moving through dependency trial and TPR trials? If their lives and livelihoods depend on a good relationship with the parent, then we have some concerns, again, about their objectivity and ability to offer what's best for the child. So as a best practice, don't do as I did, do as I tell you. Get involved with the waiver coordinator as soon as you possibly can. That person will hopefully be able to also give the case management organization names of the community supports for the parent, recommendations for family members, church members, whatever, in order to provide visit supervision, safety management, and just overall support to the parent. It is much more likely in these situations that the parent will be more open to their waiver coordinator about these supports than they would be with case management or the CPI or someone else inquiring of them. Okay. We did develop a couple of hypotheticals, thinly veiled stories of cases that I have. And we'd like to walk through them with you.
This is where we put you to work, so.
Yes. I've given you my one best practice, I'm done. So I'm looking to you for help. In scenario one, the investigation regarded a 2-month-old child, and due to mother's neglect and inadequate supervision, and therefore creating a risk of harm to the child, the mother is an APD recipient and does have a support worker 8 hours a day. We are very concerned because the child had an untreated diaper rash. Mother was changing the child's formula without consulting the pediatrician, resulting in some gastrointestinal problems for the child. And the CPT found that the baby was borderline failure to thrive. And so the child was removed. And we learned along the way that mom was also a foster child and is now an APD client. So.
Okay, so what we'd like to do is move through the life of a case. We want to start with shelter and look at your suggestions for best practices for information gathering, and then, putting that into practice at the shelter time, at the case planning stage, at judicial reviews, and at permanency reviews. So I'm going to leave the fact pattern up here so we can see that. All right, and let's start with shelter. What, from the get-go, what kinds of information gathering would you be wanting to do? Okay.
I'd want to go ahead and get that release of information from APD to know exactly what level the mother is on, because until you know that, you can't really go to the case planning stage because you don't know what services would be appropriate for her.
Excellent, and you're even jumping ahead, so that's wonderful. Someone had a hand up over here?
I'd ask the court to release the CPT report.
Okay. Good. More information? Anybody else?
Get the release, the APD release.
Yeah, that's,
okay.
yeah, our first participant said that. So
Right.
get the release, and then once you get that release, what specific documents are you going to be concerned about?
I'm going to preface this with, I don't do dependency cases, but for APD documents, I want the support plan, the cost plan, and the last notice of I-budget amount, because that's really going to have what services were approved.
Exactly, excellent, yeah. So then you've got, as this lady was saying, you know exactly what's on that support plan, what's Medicaid reimbursable, because we always have to keep in mind this is a federal program. So anything we're asking that support worker to do that's not included in that support plan is really not fair to them, and it's also probably Medicaid fraud. So, okay, so then move on to case planning. Any more information gathering? Okay.
My question would be, is there a type of notification? Because often, I'm a parent's attorney. Oftentimes, we don't even know the child has APD until we get further along in the judicial review process. And then they'll say, well, we'll consult with APD to see if that can be an approved. So is there like a notification that we can find out if the
All right,
child?
we're operating under the assumption that the parent is the APD recipient.
Okay. I was just getting clarification about that.
okay.
But sidebar, is there a way we can find out, like as a parent attorney? Like, because DCF doesn't tell us.
would say talk to your client. You know, just, you know, get to know them a little bit, get their personal information. I don't know how realistic that is.
You would also as a parent's attorney, you would receive a copy of the CBHA, the Comprehensive Behavioral Health Assessment, or the Family Functioning assessment in each case.
And that information is supposed to be in both of those documents?
I
or-
would not promise, but I would say usually, especially since the information about the parent is part of the CBHA, their history, their upbringing, their cultural background, and if the parent is an APD recipient, that will most likely come out in that discussion.
Okay.
I can't guarantee it, but I can hope. Laura, the APD lady.
Okay. I'm gonna burn my calendars.
Was your question, were you asking the converse, is your question, how can the parent find out if the child has services? I think I misunderstood. I want to make sure what you were asking.
It was more so geared towards finding out if the parent already has those services.
Oh.
I know, speaking of the CBHA, we get a lot of incomplete CBHAs, it's just regurgitation of what was in the shelter order, what was.
Okay. I think I misheard her question. I want to make sure
So did
because,
I.
sorry. No, that's okay. I want to make sure since,
I'm just trying to make sure, because oftentimes this could be beneficial
okay.
to moving the case along, if we know that there's other services that the parent can engage in, but if I don't know
Right.
that they can get APD or are beneficiary of APD, I was just trying to figure out what the notification.
Okay.
Okay.
I will also offer to you anecdotally, at shelter, mother brought her APD worker with her. And that, in one of the cases, not this fact pattern, but another fact pattern, the mother's attorney, appointed attorney at shelter, so this is not someone who knew mother well, asserted that since the APD worker lived in the home, there would be somebody there 24/7 to care for the child, which we take issue with, but so you would at least find out that mother did have those services, and then go further in terms of finding out how much money and how many hours and all of those pieces are involved.
Question? Okay. I'll get in trouble if you don't have a mic.
I don't know if this is a question, but in my area, the CBHA takes a minimum of 6 months. I've never seen one before the case plan's accepted. So it's not of any use for that. We always get them well after. Sometimes the
Thank you,
family
I feel
functioning
wonderful that the 20th is better than somebody else in something.
assessment. So I'm not sure how to address her question. Sometimes we don't get disposition reports anymore, so it's not in that.
Right.
Sometimes it's in the family functioning assessment.
Yeah.
And sometimes it's in the shelter. But that's
Yeah.
about it.
Thank you.
Hi, just to go back to your initial suggestion about getting the waiver or the release so that we can get the APD records for the parents. I'm also a parent's attorney. I have a case right now where I got my client's release and I contacted APD to get her records. My client has had APD services for quite some time, but I had a hard time getting all of the documents. They said that, they wanted some payment, and I understand that they're very, lengthy documents, but I kept saying that my client has a right to these records. So I don't know if there's a suggestion, because I'm kind of just now learning all of this.
Yeah, well, I have not encountered that. Perhaps our APD person can help us.
Yeah, we'll let our APD expert answer that, excuse me.
I don't know if I'd say I was an expert, but anyway, so it depends on how you request the records. Did you request them in the form of a public records request, or did you do it in the course of a litigation format. Notice I carefully worded, I'm being very lawyerly right now. And that could have been it too. What circuit are you in? Oh, you're in my region, so see me after, we'll talk about it. I'll be glad to try to help you out. So, I have 4 judicial circuits in the central region for anybody in here, 5th, 9th, 10th, and 18th, so yeah, we'll try to help you out.
Thank you. Okay, another question?
I actually have a two-part question. Earlier in the presentation, you made a statement that the services are not to make them a better parent. I wanted to ask a two-part question in the sense that I have a case right now where you said in order for the case to come in, the child has to be abused, abandoned, or neglected. This is mom and dad's first child. Mom and dad are both disabled. Mom is physically disabled and dad seems to be delayed. They both live with their parents and their parents are caring for their newborn baby. I don't believe that there's a dependency issue. And we're actually trying to get it dismissed, but how do we do that when the department is saying that the child has been abused, abandoned, neglected, when there's really, all they said was dad couldn't change the diaper properly, but dad's not the primary caretaker for the child and doesn't even stay with the child alone. And my other question, I guess, would be, if APD doesn't provide parenting or a course for these parents, then it's not necessarily, I'm not necessarily asking the question of making them a better parent, but an equipped parent.
Okay.
Can they provide those services?
To Part A, I tend to agree with you that you don't have much of a shelter petition going there. But to the second part of your question, if a child has been taken into care, one of the tasks that a parent will get from the case management organization would be parenting. And I think that's the other best practice tip I have to offer: be patient. It may take more than one round of parenting class and perhaps one-on-one parenting to see the benefit with the parent. But we're not saying because a parent is an APD recipient that they can't learn. They absolutely can. But we do have to be cognizant of their delay and not hold that part against them. So what we're looking, the services are available for parenting through the case management organization and the case plan. But again, this may go beyond the 12 months that we normally say it takes to complete a case plan. And it may take 2 and maybe 3 rounds of parenting. But we could see the improvement that's necessary. So in answer to your two-part question, I've got 2 answers. There's one in the back.
So just to mention real quick, so when we're talking about case planning, and Janet mentioned, being patient, a parent may need to repeat a parenting class more than one time. Also look at the format of the class. I mean, if it's just a group lecture type thing, that might not be suited for that parent. Maybe they need the one-on-one, and depending on what's available in your circuit, you might want to be proactive in looking at that.
And is there a reason with this fact pattern that there wouldn't have been some kind of diversion first before shelter? I mean, if, for example, there's healthy families, visiting nurses, parents as teachers. I mean, if at APD, if someone with APD was assisting mom and thought that that would be appropriate, would there be any reason why the APD what's the name of the person assisting mom?
Support worker?
Okay, the support worker wouldn't reach out to those resources and get them in the home to prevent shelter or removal?
That really would not fall to the support worker. It might be something that the waiver support coordinator would look into. That's the person who's looking at the free, if you will, support system, the natural support system. That would be the person who might do that. And again, the fact pattern really starts with the shelter. So one would hope that the child protective investigator who initiated the investigation and learned that mother was an APD recipient, that person would have reached out to the waiver support coordinator and perhaps found some other supports for the mother. You're absolutely right. I mean, the effort is to keep the child in the home before we even get to shelter. And so I think we have a lack of information. A lot of this is very new to me, and I've been doing dependency for 4 years. So again, as I said earlier, don't do as I did. Do what we're talking about. And best practice is to bring it up as soon as you can and involve the APD waiver support coordinator as soon as you can, because they're the key to those other services.
Did you still want to add, or she picked it up? Okay. I don't need the microphone. I get in trouble if I don't give the microphone. Yep.
When the waiver support coordinator or the APD support worker find out that the woman is pregnant, do they at that point try to engage in some type of services for the parents at all to educate them or to try to educate them on caring for a newborn baby, which I can tell you wasn't so easy, and I have pretty good education.
And I wish I had an answer for you. I
Do we know
not
if
know
they do?
what-
Because I think, I mean, and that could even go even when it comes in, like under the case that you were talking about, Alexa, where you have both parents who have some delays. If we could get them services through APD, we might be able to get the case dismissed.
Thank you. Sorry. That's okay.
Assuming all the facts that you've presented, I mean, what we would normally do in my county is probably the parents would execute a power of attorney to the grandparents for them to be the primary caregivers. If the parents weren't of the capacity to be able to do that, that might prevent that. But I don't understand why they wouldn't have just done under methodology a safety plan and implemented some services through that before they went the judicial route. So even if you get your judicial case dismissed, they may still want to do some sort of voluntary protective services or safety plan type of parenting. I mean, I would think they should be able to hook you up, your clients up with that way.
This is great. People are really thinking out of the box here, and even before we would get to a dependency, what would happen, so.
And again, just because a parent receives APG services and has a child, that does not open them, and bring them into the dependency system. There has to be an allegation of abuse, neglect, or abandonment that is investigated and then brought to a shelter hearing. So the case that you described, the young lady in the third row describes, that one seems a little shaky, yeah.
Yes.
I just wanted to make a note for the people in the audience. Certain clients who are getting APD services might not have a mental disability, it might be physical. So these are people with completely intact cognitive functions in some cases, so.
Good point, thank you. Yes.
You keep saying that, just because they're an APD client, that doesn't mean it brings the child into care. But I would disagree based on this scenario. I don't see any grounds for removal based on an untreated diaper rash, changing formula, or a borderline failure to thrive. I mean, this is mostly risk of harm. It's not abuse, abandonment, or neglect at this point. Or there's no confirmation of abuse, abandonment, or neglect at this point.
Well, we pulled this from the actual case. These were the allegations, and shelter was granted. We're just, this is just a place to start a discussion.
Yeah, I'm just pointing out that I don't necessarily think that's true. I mean, I think the fact that the mom is an APD client or the parents are APD clients is what brought this scenario into place. If you're looking at just the allegations, I think if you have a client that's not APD, an untreated diaper rash, changing formula, and CPT may be thinking there's failure to thrive is not going to be enough to warrant a shelter.
Yes.
just to disagree with you, and not because I'm disagreeable, but I know 30 years ago, kid died from diaper rash. The borderline failure to thrive can be quite significant if you're talking about a child that's actually being starved to death. So under the circumstances as I see them, there very well could have been legitimate reasons to shelter in this instance, but not necessarily a reason not to return the child. Right. There might be reasons to work with APD, but also to work with case management of the child to determine if they're through parenting classes, parent training, so on, that you can work with this family for reunification.
Well, and I think that's the key that we're trying to focus on. I mean, shelter is probable cause, it can be risk of harm, but at that point, you know, once you realize what you're working with, there's very limited case law on this. Since I'm an appellate attorney, that's what I always look at, and there really isn't any. There's one case I found, it was really interesting. They actually affirmed a termination of parental rights, but the citation should be in the notes to the PowerPoint that are on the app, but you can let me know, give me your email, and I'll send you the case if you'd like. But there's a really interesting discussion by the dissent, contrasting cases where, I mean, it may just be an APD parent and there's just a developmental disability. And like Janet said, we need to be prepared to provide maybe one-on-one services, maybe let them go through it more than one time, maybe even go beyond that 12 months, you know, if there's a reason to. But what the dissent did was contrast cases where it might not just be the developmental delay, it might be domestic violence, or it might be substance abuse or things like that. So the dissent would have reversed the termination because this was a child who came into care through no fault of the parent, and really chastised the lack of reasonable efforts, which in that case, according to the dissent, would have gone above and beyond what would normally be reasonable. And you know, I mean, that's the goal. We want these kids with their parents, and we just want them to be safe. So, so we're through shelter, we're through case planning, judicial reviews down the line, anything you're going to be looking for or anticipating in advance of that judicial review. Any thoughts on that, or even permanency review? Yes.
That if we've already signed the consent, or the parent has already signed the consent, I would try to hopefully be looking to either have my CAM or myself and the CAM meet with maybe the support worker and the parent and their attorney, and try to see what we can kind of come up with that will assist the parent and the child in reaching permanency, instead of just moving straight on to, change the goal to adoption.
And I think that's key, staying on top of it, communicating, really being collaborative in these cases. I think that's an excellent point. Other thoughts? Yes.
If you're reviewing like the services on an annual basis between now and, you know, shelter and permanency, they might have added or subtracted a few things which could benefit the parent, not necessarily in assisting the child, but assisting the parent so that they could assist the child in a sense.
Yes. Good point.
Yeah, and that would come down to your communication with the support worker, with this waiver support coordinator, so that you know what's going on, because those services can be altered, and if we've got a shelter of a child, that would certainly warrant looking at what they're doing. So, other thoughts? How are we on time?
5 minutes.
Okay, so we probably shouldn't start our
till 2
next.
o'clock, right?
Yeah, we probably shouldn't start our
5:10.
next scenario. There is another scenario in the PowerPoint for you to think about, but any last thoughts? Yes.
It's a little off topic from this scenario, but I guess my issue is in dependency cases, we have kind of a fast track. You know, you get a year to get in and get out, and a lot of these parents that need APD services may have been waitlisted for some time. Or, I mean, are you all aware of any way to expedite a request through APD? Because we run into those issues more frequently than we actually have parents, and I'm parents counsel. But we run into the issue more regularly where we're trying to get them, you know, the APD set up initially versus the scenario where they already have a support worker in place.
Unfortunately, I have not had any success in that area. We have represented a young person who was aging out, who was denied APD services and did succeed in getting her wait listed, but never to expedite the wait list.
I can maybe help a little bit with that. So is your question, how do you get, is your parent on the wait list?
I've had some that are, and I've had some that are just trying, where the caseworker's trying to help them get on the list because they've never really known how to do it.
Okay, so we have staff in every region that help with intake and eligibility. So if you're having an issue with that process is relatively, air quotes, fast. Once you're determined, if the person is determined eligible, generally they go onto the wait list. It is quite extensive, thousands. I will not make any bones about that. However, there is categories of prioritization. There are 7, 1 through 7. Category 1 are those persons that are deemed to be in crisis. So if you're wondering how can I get them actually enrolled from the wait list into the waiver, there are 3 categories within category 1 that are deemed to be in crisis. Those are, and they have to meet one of these eligibility criteria for crisis, which are, and they could meet 1, if not all 3, homeless, danger to self or others, or both of those. And the third one is caregiver unable to give care. And that's a separate application. Their caregiver, the APD waitlist individual, is their caregiver is unable to give care to them. And can I just make a couple comments? I'm sorry. I just want to maybe qualify a couple things. You guys have done an excellent, not that it matters what my opinion is, it's not really an opinion. I want to just let everybody know on support coordination, yes, the different levels. Support coordinators, regardless of the level of support coordination that your individual, your APD parent receives, the support coordinator has to be available 24/7 to the parent. Whether it's limited support coordination, and actually that applies to only children that receive support coordination, and then generally a person that's an adult, that's a parent, would be receiving full support coordination. And so their support coordinator needs to be available 24/7. And we expect them to return their calls. If for some reason, they have to leave them a voicemail. I just want to make sure everybody knows that. So, and then the other thing I wanted to make mention of was that you were correct in that a direct support care staff, there are 2 types of providers: solo providers, so that if I'm a provider and I'm by myself, I can be, providing services directly to an APD client, or maybe I have an agency and I have employees that work for me. Yes, I can, if I'm a solo provider, I can be fired at any time by the client, but I cannot just quit. Or the employee, if I have an employee and I'm an agency and my employee quits, but if I'm an agency or if I'm a solo provider, I just can't quit at any time. I have to give, by Rule 65G, I think it's 3, I have to provide a 15-day notice of termination of services. So I just want to let everybody know that. We don't leave clients just hanging out there with services without service provision, because agency for persons with disabilities is ensuring client choice and the health and safety of individuals that we serve. So, just wanted to say that.
Thank you.
Thank you.
Thank you very much. Yes.
One thing I suggest maybe everybody does is that all of the agencies that serve the state that working with our children and families, there's an interagency agreement that is required that details the requirements for coordinating services for our families, and it was just updated in 2017, and it's applicable to 2022, and it's on the Center for Child Welfare, but it includes APD and includes the Department of Children and Families, so, and the guardian ad litem. So I encourage everyone to go look at it, because there's things like local teams that are supposed to help with coordination of services, regional teams, and statewide groups as well. So that might provide you a different avenue to help get everybody talking if they're not already.
Great, thank you, Matt. Okay, well, we really appreciate your sticking it out with us. I learned a lot. I think the key takeaway is keep asking questions, keep reaching out. And if we all collaborate, we'll get the best results. Thank you.
Thank you.